So, backstory for today's episode. I am a huge fan of Are You Saying Yes to the Dress? Say Yes to the Dress, okay? So, I have come across, she's not a guest, but I've come across our case study, one of the parties in our case studies for today. I've seen her collection and they are beautiful. She currently makes shoes and some other wedding accessory, but 4 years ago she had a disagreement with the company where she worked at, and I'm here to give you details about the case and also talk about what you need to know when it comes to intellectual property in the wedding industry, when it comes to contracts, And I'm still celebrating my birthday and the first anniversary of this great podcast.
Hey guys. Hi guys. Hey guys. Hey.
This is not your average podcast, trust me. This is IPSERIES, where you learn to protect and safeguard all your intellectual property so you can make a career of what you love. Join me, Rita Chinda, as we discuss all things intellectual property from the world of fashion, film, media, entertainment, dispute resolution, and even technology. Welcome. So, if you work in the wedding industry, fashion designer, you are an influencer, then today's episode has been specially created for you and all the Say Yes to the Dress fans and fans of Hayley Paige designs. So let's gather around and let's dig in. Now, when discussing fashion, it's all about creativity, the skills in the sector. I mean, have you seen wedding dresses? Kudos to Nigerian wedding dress designers or the fashion houses. You guys are killing it, especially now that Bridgerton is just going off the chart. I mean, you're seeing a lot of user generated content with Bridgerton themed. I mean, I love a good low back when it comes to wedding dresses. I'm also going for non-white, not ivory, and definitely not black, but I'm going to wear a colored wedding dress. But other than that, I get this excitement when I used to watch. I mean, I barely watch it now, but it's still one of my favorite TV shows. You know, having brides coming, picking out dresses. I mean, I did that movement with my friend when she was getting married, and trust me, it wasn't funny. And I think I had that feeling when I tried one of the dresses, which was not like my usual style. So I kind of like understand the whole say yes to dress saying. And other than Hayley Page, Pinina Tony was another well requested wedding designer, but we're not talking about Pinina today. We're talking about Hayley Page and her former boss. Now, the IP element when it comes to wedding industry is the commercial nature of the expression of the design. Now, you have a lot of people that contribute into making the dressing, from sourcing the fabric to coming up with designs. Now, sometime in December 2020, wedding gown designer Hayley Page was restricted from using her name and her social media account as a result of an emergency temporary restraining order and also failure to negotiate a new contract with bridal design house JLM Couture, where she was the head designer. Now, when I saw this news, I was like, what the hell is going on? I mean, sorry guys, what is going on? What is the deeds about this case? So I'm going to tell you I'm trying and I'm going to make it short. Okay? But I need to give you guys, so I'm going to talk about the dispute and I'll give you the updates, which is like summary of what I just did. But Stay with me, stay with me, stay with me, okay? I had carried out a poll on my account on X, formerly Twitter, asking like my IP friends and readers their thoughts on whether social media accounts created by employees should belong to and or be assigned to an employer. Now, 50% voted no, 31% voted yes, and 19% voted neutral. Zero said not that serious. That means nobody actually voted for that. Now, sometime in July 2011, Hayley Paige Gutman, who had appeared on TV show Say Yes to the Dress, just say yes to the dress. Yeah, super obsessed. Don't judge me. Anyways, she had signed an employment agreement with fashion company JLM Couture to be their head designer. And I think prior to when her term of employment was to expire, she was trying to renegotiate, but that did not work out for her. But going back to the dispute, when she signed this contract, she had so there was a clause or a provision which stated that she understood, she has acknowledged and accepted that the terms of her employment at JLM were governed by JLM's employees handbook. Um, the employee handbook states that employees will use their time during the workday solely for company business, not personal use. Internet usage is limited to job related activities, and all intellectual properties defined as all designs, drawing, notes, patterns, sketch, program, spreadsheet, database, prototype, samples, improvement to existing work, and any other work that an employee conceives or develops shall be and remain the property of JLM. Now, I'm going to read out some other clauses that she had that were included in her employment agreement. The emphasis I'm trying to lay on here is that she never gave a lawyer this document to vet or read and explain to her the implications of some of the clauses that were included. For instance, Section 9, sub paragraph A of the employment contract, which reads covenant not to compete, provided that employee covenants and agrees that during the period of her employment with the company, employees shall not compete with the company directly or indirectly. For purposes of this agreement, employee shall be deemed to compete with the company if she engages in or is associated with, whether as an officer, director, shareholder, partner, employee, independent, contractor, agent, whatever, any person, organization, or enterprise which engages in the design, manufacture, marketing, or sale of bridal apparel, including bridesmaids, mother of the bride, and flower girls, and related items, bridal accessory and related items, evening wears and related items, and any other category of goods designed, manufactured, marketed, licensed, or sold by the company. 9C provides, and I highlighted, the employee covenants and agrees that they will not directly or indirectly during or after the term of employment disclose to any person not authorized by the company to receive or use such information. This is basically focusing on confidential information and trade secret, any of the company's confidential information, which means any financial information, marketing plans, customers list, or other proprietary information of the company. Now, Section 10, Paragraph 8 talks about exclusive right to the designers, and this is part of the dispute that she was having. Remember, I had stated that she was restricted from using her name and social media accounts. Now, here it says that the employee hereby grants to the company the exclusive worldwide right and license to use her name. Haley Page, Gutman, Haley Gutman, Haley Page, or any derivative thereof, collectively the designer's name, in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessory, and related bridal and wedding items, including any and all goods will be associated with. So I think one of the reasons why Haley really stood out for me was I was watching one of those episodes where she was called in, and this piece she had brought in was really, really, really. Can't remember, but it was good. That's how I said following Haley. So when this came up, I was judiciously following this case just to know how it was, because I mean, he also drew my mind back to the Cynthia Morgan case where she was alleging that the record label company owned her name. It's not like you can't trademark your name, but when you put in a contract that you have assigned and granted exclusive is just you and party A, not non-exclusion. Worldwide right and license. I mean, Ogini. Anyways, let's read part B of that. It talks about trademark rights. The employee hereby irrevocably sells, assigns, and transfer all rights, title, and interest of the company to the company that now exists or may exist during the term and for a period of 2 years thereafter, to register the designer's name or any derivatives thereof. Trademark basically protects distinctive names capable of distinguishing brand A from brand B. So imagine Haley or Paige or Haley Page, or Haley Page Gotma, or Haley Gotma, or Haley Page, or any other derivative name being transferred, assigned, and sold to JLM Couture. And then they are stating that for a period of 2 years after, they will register her name or any derivative thereof as a trademark or service mark, and the trademark shall in perpetuity be the exclusive. Oh, oh my God. Seriously. Be the exclusive property of the company, the employee having consented to it being filed by the company, and the employee therefore shall have no right to the use of the trademarks. Trademark is territorial, so this just applies to the US. Um, let's see. Yeah. Then it goes further to say the employee shall have no right to the use of the trademark, designer's name, or any confusing similar marks or names in terms of commerce during the term or any time thereafter without the express written consent of the company. The company shall be solely permitted to license the trademark to a third party. What you guys actually sign? I mean, get a lawyer, okay? Section 11, design and IP, which is intellectual property. The parties expressly agree that all designs, drawing, nose patterns, sketches, prototypes, samples, improvements to existing works, and any other work conceived or developed by employee in connection with her employment with the company involving bridal clothing, bridal accessories, and related bridal or wedding items, either alone or with others, from the commencement of the employment by the company through the terms of employment agreement, and work for hire, and ownership of any IP arising from or related to the design shall be the sole and exclusive property of the company, which in this case is JLM Couture. If for any reason the design or any portion thereof are deemed to not be work made for hire, the employee irrevocably, absolutely, and unconditionally assigns three hefty words or three hefty terms: irrevocably, absolutely, and unconditionally assigns to the company all of rights, title, and interest. Like seriously, I'm sure if I am reading this kind of document, I would just be like, sparks would just be flying left, right, center. Because she was just in, I think, her early 20s, and probably excited that she got this huge offer from DJLM Couture. Okay, So I'm not going to be judgy, but I want us all to learn from this. Now let's follow the timeline. Remember, she got a job in 2011. Now, on the 6th of April 2020, she created the Miss Shelley Page Instagram account, which I still follow. Okay. Then 2 years later, in 2014, she created a Pinterest account with at Miss Shelley Page handle, and also joined TikTok using the same handle in 2019. That's pre-COVID. And this dispute started um, a year and a month later, sometime in December 2020. So, should she have created a personal account in her name? I mean, everyone has a personal account, but if you now have to share content on your personal page, I mean, Instagram has now introduced some sort of collaboration tags where you can also tag other persons in your account, which is a good thing. But all of this was post COVID, and I think in the last 1 year that this was rolled out pre Hayley Page dispute. So I think if this had come out, this whole adjustment to the Instagram account has come out, I mean, it would have been perfect for Hayley to be able to separate. I mean, in this digital era, a lot of us are still finding our feet, trying to understand how the social media algorithm works, separating your brand from your personal self to your professional self to the part you really do not want people to know. I mean, we've been there, still there, and still figuring shit out. But then, when she failed to now renegotiate her new contract, that was when JLM sued her for breach of agreement, unfair competition, trademark infringement, and then they wanted to enforce the non-compete clause that was in her contract so they can gain control over the social media account. Because when I recently checked it because of this case where I was doing my research, I saw that the last post that Miss Shelley Page had shared was sometime 20. Wait, I need to get that right. Is that 2020 or 2022? Hold on. It's actually December 10th, 2020. And it was a picture of her and her now husband. And then the most recent post was 3 days ago. That would be, let's see. Okay. But, anyways, she recently posted and tagged her three other accounts which she has, which is a girly you might know foundation, all that glitters on the gram, and she is Chevelle, which is like her wedding accessory page. She has a shoe collection, lovely shoes. There's this pearl white shoes that she posted. It is really gorgeous, and that was posted on 10th of May for anyone who is interested and likes stuffs. But yeah, you see that on the She is Chevelle, she's kind of mixing everything, not just her shoe brand, but also herself, trying to show herself. But I think it's all about, just creating content and being all there. So her most recent post on Michelle Page reads special announcement coming soon, and I am sitting at the edge of my seat waiting to hear what the announcement is. Turned on my notification already. But yeah, after she failed to renegotiate, they were now trying to enforce the non-compete in her contract. Now, what is the update I was talking about? Sometime this month, JLM was directed to provide the current username and password for each of the disputed accounts, as well as any other assistance necessary to access and gain sole control over the disputed accounts. And Hayley Page, okay, it's supposed to give it to Hayley Page through her lawyer as at 5 p.m. Eastern Standard Time, 15th of May. 2 days before my birthday. Okay, so um what the court recently held was that in New York court, a New York federal judge issued a mixed ruling. A lot of the publications I saw were like, this is a mixed ruling in the dispute between Haley Page over the use of her name. First was that they have the JLM Couture failed to show a likelihood of success in establishing that it was the original, they were the original owner or transferee of the account, and that the evidence before the court showed that Haley Page Gutnam originally owns the account and never transferred it to JLM Couture. Okay, hold on. Give me a sec. Okay, and we're back. So that was like the major one, the court stating that there was no likelihood of success in establishing that they own. And then the second one would be the order to restore her account details back to her. Now, we're moving on to matters arising. Some of the matters arising for me, the right to use, what was it really a right to use Haley Page in the promotion of bridal designer product? I mean, her collection was basically called Haley Page. So she was already being allowed to create designs in her name. Um, Haley Page signed a contract without a lawyer. That is a big red flag. The rise of Haley Page. So you get, I don't want to stress that. And then the enforcement of the non-compete clause. What are the do's and don'ts for um wedding dress designers? Ownership of social media accounts, which 50% of you said it wasn't right for an employee to transfer or assign their social media account to the employer. Trademark infringement, we already know, is the unauthorized use of a mark that's going to cause confusion amongst consumers. You'll be suing for passing off where it is not a registered mark. So the question begs that now I will be asking is, was Haley Page registered as a trademark that JLM Couture was suing Haley for trademark infringement? I mean, I haven't seen the judgment, but from everything I've read online, breach of contract, unfair competition, um, that was being alleged. So, what is the effect of the Federal Trade Commission over non-compete clause? Is it possible for an employee such as Haley Page to assign their goodwill to their employer? Content of a non-compete clause, and then should you or can you make your name a trademark? So, what are the lessons that we can take from this conversation? So, what can prospective designers take from this? First, very important that you review and vet every clause with your lawyer before you sign any agreement. Define who owns every IP created, including your social media account. I mean, we're in the digital era, people are owning content, hashtags, etc. There's also compliance with advertising, marketing policies, and now we are dealing with artificial intelligence, created works, etc. Your jurisdictional law will determine how non-compete clause will be enforced and its implication. Have a renegotiation clause that gives you an edge so that you come back stronger and you're like, yeah, I'm here. This is what I want, and I need to get it. You know, important tips for employees about IP and non-compete clause. First of all, the intellectual property right for bridal designers and businesses. First, because of the tangible nature of these designs, designers and businesses would consider their jurisdictional protection. and compliance requirements such as licensing, employment issue, online sales, production, manufacturing, sustainability, originality, and industry standard. Then you're going to consider the protection for your original wedding designs. A wedding designer can consider a multi-layered IP protection for its brand, starting from copyright to trademark to design right, patent, confidential information, n- non-soliciting or solicitation, and I'm not going to non-disclosure, and also before in the US non-compete clauses were included. Now with the new FTC rule, it has been abolished. So um as a result of this, we're going to look at also the implication and what wedding designers and influencers can learn from this case is understanding the importance of having a clear language, understanding of contracts, um, the types of dispute that they may encounter, and then intellectual property rights, which we're currently talking about. So remember in this case that the company's good will associated with the high profile of product lines that were built in conjunction with Hayley Paige during her employment around her name was transferred to JLM under a contract. That is Section 10B, which talks about trademark rights, Section 9C, which talks about non-disclosure of company's confidential information, exclusive right to Haley Page name. Even gave examples: Haley Page, Page, Haley Gutnam, Haley Page, and any other derivative name that she will create. Then you also have disclosure and endorsement. Influencers must disclose their partnership with brands, making it clear when content is sponsored or contains affiliate link. I'm talking about this because in the reports I had read, um, JLM had accused Haley of creating influencer related content on the Michelle page where she had links and stuffs like that on the page, and that it was done without their approval, and all of those drama that came with the dispute. So I'm trying to look for. So I'm currently scrolling through Michelle lovely dresses. Oh, lovely, lovely dresses. So I'm scrolling through. I don't know if it's this particular page, or let me check the yeah. Let me check the all that glitter page. I think that's where she posted what I'm actually looking for. Aha, yeah. Because so one interesting thing was that when the FTC ruling came out, she made a post about it on the same day. She's not being petty. She's just thinking like a creative who wants to see um things done differently. I would like to assume. Okay. Uh seriously, okay, why is it taking me so long to get to this page? But hold on. Also, the story is long. I just saw a post that she made sometime 14th of December stating that JLM seized a commission to her for previous designs since November of 2019. That was even before the dispute. And they also prevented her from using her birth name, including derivative, for commercial purpose. Nobody's stopping you from using your name just for commercial purpose, okay, honey? Um, Yes, also sued her fiance and now husband for using her name to identify her on their podcast and social media. May right of publicity, guys. Stop that from talking about future plans and announcing any new name. Hmm. Oga. Oga. Seriously? My former employer, JLM Couture, sought and was granted a content order against me. It requires me to delete several videos and posts I made on Instagram by September 13, 2021. I was disappointed, but have no choice. People that obey court order. I'm not referring to anybody, but I'm just saying. I mean, it's interesting if you actually take your time to go through. Hmm. So she actually posted. There was a post she made on my birthday in 2021 on all the glitters on the gram, stating our current gown sales still benefiting you. No, despite JLM's contractual obligation, they stopped making payments to me, including dress commissions for the 2020 fiscal year. If you possess a dress from since November 1st, 2019, I've not received any commission for that gown. I have countersued JLM for breach of contract due to their failure. The matter long, but me, I want focus on the I want to focus on the IP elements. Um, I know some persons have their views. So copyright will protect the artistic works such as sketches, drawing, prints, mood boards, videos, broadcasts of BTS, as behind the scenes video shows, TV shows, work or artistic craftsmanship, including pictorial wooden tissues and articles of applied handicraft, irrespective of the quality. So remember when I was looking and reading out her some the terms of her contract where I listed a bunch of things that included as copyright or as intellectual property, such as designs, drawing, notes, patterns, sketches, programs, spreadsheet, database, prototype, samples, improvement to existing works. Then we're going to be looking at design rights protection for three-dimensional forms. So let's see. Yeah, let's see the design. Yeah, design and IP. Designs, drawing, notes, patterns, sketches, prototypes. I already read that for you. It must meet the basic requirement of being new and not contrary to public policy, um, morality. It's also, so I'm looking at this from the Nigerian perspective. We're under a law, something that is new or presumed to be new as at the time of publication. However, where the design was made available to the public by means of, say, description, the applicants will have to show the the registrar to their satisfaction that they were not aware of any disclosure. If it was disclosed or shown during an exhibition 6 months prior to filing the application, it will not fail. It will not fall under public disclosure. And finally, the fact that a design is different based on a minor or inessential way does not mean it is indeed new. So what types or what happens to design made in the course of employment? So remember the post I was reading where she stated that the dresses she had made, and if anyone had purchased them from um, November 1st, 2019, she wasn't getting any commission for that. Now, under our law, the Nigerian law, it provides that any design created in the course of employment or from the execution of a contract, like the one Hayley Paige had with JLM, for carrying out specific work, okay? Specific work will include um, making of dresses or any category of goods designed, manufactured, marketed, licensed, or sold, or including bridesmaids, mother of the bride, flower girls, flower girls, okay, or sale of bridal clothing, related bridal and wedding items, including any and all goods associated with, the company. Um, JLM owns the design. However, where Hayley, as an employee of JLM, as the head of design, contract doesn't require where her contract does not require her to exercise creative activity, but has been creating design using JLM's products like office materials, samples, spreadsheet, data, prototype, etc. JLM shall be entitled, that means now Hayley shall be entitled to a fair remuneration into her account, um, for salary and the importance of the design. And also, if you've seen any of the episode of Say Yes to the Dress, where Hayley Page's dress was advertised, you will agree with me that she deserves every fair remuneration as a creator and is also entitled to not modify her contract, which may be enforced by civil proceedings. So this is under the Nigerian um, law, what is required when it comes to IP. Next up, I think we already dealt with trademark where I talked about Hayley Page name. She wasn't also allowed to change her name um, because her name for commercial purpose strictly. They're not paying her for using her name, but they're just preventing her from working, which is what she stated on her account. Don't want to be biased. She I mean she was just making emphasis on I never got paid for JLM using my name, but if you look at that trademark rights clause, it states that she transferred. I mean, ignorance is not an excuse, but I guess everyone always, I mean, we all make mistakes, let's put it that way. In this contract, it is assumed that JLM owns Haley Page Gardner in perpetuity and is the exclusive property of the company. I mean, this is an unfair contract. Okay, but I'm going to emphasize on that later on in future. Stay with me. Okay. Then yeah, I was going to talk about trade secrets and confidential information, which gives one an edge in the wedding industry over other designers and fashion houses. The elements include suppliers of fabric and other materials needed to make a customize a wedding dress, buyers, software or tech used to shorten production cycle, track delivery and logistics, and the entire value chain when it comes to wedding dress production. Tech used to customize a bride's look. Also has interplay with data protection and when it comes to handling of information of customers and also other employees as well. Protecting your design in the wedding industry can boost a brand's revenue through licensing, um, sell partnership collaborations for a limited collection. Example could be maybe Haley Page teen bridal Bridgerton collection. I mean, I think I saw one from, it wasn't a wedding dress per se, but I've seen a couple of wedding dress stores and brands um have all this UGC content out there, and they're like Bridgerton inspired dresses, and yeah, so many options. And I'm like, oh, I love this. Oh, I love that. And then I'm like, there's so many. There's just so many for you to pick out of. And I won't blame anyone. I mean, have you seen the content out there? Um, Trademark and branding as well. Wedding designers, fashion houses like JLM and other service providers in the wedding industry can rely on trademark to protect their brand names. We are getting to the Ogidi Gbada. Hmm? The main. I wouldn't want to delve so much on unfair competition because it wasn't really like the core conversation in this dispute. So bear with me. Now, non-compete clauses or agreements in the fashion industry have been common for a very long time. They have been used to prevent employees from working for competitors, from being poached for starting competing businesses within a certain period of time, maximum 5 years, minimum 2 years. In Haley Page contract and JLM, it was 2 years. Should she have waited it out? Not sure. But the enforceability of these non-compete clauses would depend on several factors, including the nature of the relationship between parties. And we'll see that post negotiation proceedings or conversation with JLM, Haley um, relationship with JLM could not be said to be a very likable one. But prior to that, it was really lovely. I think there was somewhere I read that it was JLM that helped get her to be featured on Say Yes to the Dress. Have you met Randy and the other team members? Hmm. Anyways, the specifics of the underlying transaction and following the FTC rule, which bans post-employment non-compete clauses between the employers and the workers, I wonder, I don't know if every other person was wondering, I wonder the fate of Hayley Paige might be in this new development. Now, again, on her page, all the glitters on the gram. She posted, they are finally banning non-competes bum 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 exclamation mark. Okay, thank you for reaching out and throwing support my way in light of this game-changing news out of the Federal Trade Commission. I have been very vocal on my opinion of non-compete. In my mind, they are riddled with a mentality of scarcity that hinders innovations and designs. They stifle competition, leading to inefficiencies in the supply chain and customer service. They threaten the American dream. What is your Nigerian dream as a fashion designer, as an IP owner? What exactly is it? So, what are the implications of a non compete clause for employees? One, it can shape or make or break your career trajectory because of the constraints that has been imposed on you. They extend well beyond the tenure with a company, like in Haley's case, I stated previously, which the courts have often determined to be reasonable, that 5 years from the end of JLM employment relationship with Ms. Gotham is reasonable. Um, is a reasonable amount of time, no greater than is necessary for JLM to rebuild its brand, develop a new strategy, and distance its products from Ms. Gotnam, whose persona was intimately tied to the eponymous brand. So let's look at the publication. So the court concludes that 5 years from the end of JLM's employment relationship with Ms. Gottheim is a reasonable time to rebuild. The court concludes that paragraph 10E, which is like the five-year term, is reasonable in duration. The worldwide scope of the restriction is also reasonable because JLM's business is worldwide. Is it really worldwide? Does anyone knows JLM in Nigeria? Just asking. So it goes to the extent there is any ambiguity as to whether the restrictive covenant in paragraph 10 sub E runs from the end of the contract term, which expired on 1st of August 2022. So she was trying to renegotiate her contract 2 years before her contract even expired. And from the actual cessation of Ms. Gutnam's services from the contract, it is undisputed that Ms. Gutnam has not designed products or otherwise performed work for JLM since her resignation on the 17th of December 2020, because JLM was on notice of its need to rebrand its brand, to rebuild, maybe no, to rebuild its brand, develop a new strategy, and distance its product from Ms. Gutnam on that date. I mean, it's an interesting case. Second implication is that the enforceability of non-compete clauses differs depending on your jurisdiction, as courts carefully analyze the terms to strike a balance, protect a person's right to work, and also keeping legitimate business interests. The court will have to assess various aspects such as the restriction duration, the geographic scope, and the specific activities prohibited. They also need to make a non-compete clause. To make a non-compete clause enforceable, the employee must receive some form of consideration such as compensation, promotion, or access to valuable training. And it also limits and controls an employee's engagement from working for competitors or starting similar businesses in a specific area and time frame. So remember I said if Michelle Page now has three accounts other than Michelle. She has all the glitters on the gram, which is like her wedding accessory, shoe accessories, and she also posts her advocacy stuff. Then she has a girly foundation, which is a non-profit organization to protect young creatives. And then she is Cheval, you know, luxury shop and retail. Just haven't seen her post any specific wedding dress. So you can imagine being stifled, or you just somewhere sitting waiting for 4 years. And I hope these 4 years she has been coming up with very, 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 very lovely, lovely wedding design dresses. I would love to see what she's coming up with, especially now you have a lot of fashion designers, wedding dress designers. Oh, as in, I'm tired of saving pictures, but I love weddings. I love the industry. I love how it just, I don't know how to explain it. Maybe it's the Romance in me, Riri. Okay. But yeah, the interplay, we're going to talk now about the interplay of non-compete and trade secret protection. What is the interplay of non-compete and trade secret? Remember, trade secret protection is for confidential information, and this was part of what was included in Hayley Paige contract, while non-compete is usually through restrictive covenants, which was also included in Hayley Page's um, employment agreement, which seeks to protect JLM Couture even after she has left the company. Take note that a court cannot rewrite a contract that has a restrictive covenant, such as a non-compete, as we've seen in this case for JLM, which is the employer, or any other employer, as the case may be. There is also the public policy consideration for an employee's duty once they leave an employment, which provides that HP, which is Hayley Page, can use her skill to earn a living, and even though they may have learned this as a result of their employment, they are also entitled to earn from it, from the desirable objective of a free employment market. Now, only important commercial information is protected or enjoys. Oh my God, my phone just fell. Enjoys protection as a trade secret or confidential information, as the case may be. And Hayley Page owes JLM post-employment dispute. Now, this will depend on the nature of the employment, the nature of the information itself, whether the employer impressed on the employee, the confidentiality of the information, and whether the relevant information can easily be isolated from other information that the employee is free to use or disclose. Furthermore, in the case of Herbert Morris Limited against Saxby, the court held that an employment business or a legitimate business interest includes the goodwill with customers, trade secrets, and relationship with employees. Now to the Bedu of this case, which is like the summary of the FTC rule banning non-competes, which seeks to protect competition by banning almost all non-compete. It also protects or seeks to protect the fundamental freedom of works to change jobs, increase innovation, and foster new businesses in the United States. Now, who does this apply to? Basically, senior executive and other work employees. Employers are now banned from entering into or enforcing new non-compete clauses. So remember the Hayley Page post where she was excited about this rule. This is why. Um, this rule is said to be in violation of Section 5 of the FTC, which is the Federal Trade Commission Act, which prohibits unfair or deceptive acts or practices in or affecting commerce, including banks. So, example of unfair acts includes unfair act or practices will include where it causes or is likely to cause substantial injury to consumers, is not outweighed by countervailing benefits to consumers or to competition, cannot be reasonably avoided by consumers, while deceptive acts or practices will include misleading representation, commission, or practice is immaterial. A representation, omission, or practice misleads or is likely to mislead the consumers. And finally, a consumer interpretation, omission, or practices is considered reasonable. Also, according to the Federal Trade Commission, the attempt or the the alternatives available to employers to protect their investment or proprietaries, such as intellectual property, would include trade secret laws and non-disclosure agreement or clauses. Unfortunately, Nigeria does not have a trade secret law. However, employers and employees are encouraged to either include a non-disclosure clause or draft a separate non-disclosure agreement that will protect the employer post-employment duties, um, as required for the employee, and also included model language which reads as follows. As of the date employer chooses, but no later than the effective date of the final rule, which is 120 days after it was published on 23rd of April 2024, the employer, which in this case will be JLM, will not enforce any non-compete clause against, in this case, Hayley Paige. This means that as of the date employer chooses, but no later than effective date, you may seek or accept a job with any company or any person, even if they compete with, put the employer's name, which for this case, we're going to use JLM Couture. You may run your own business even if it competes with JLM Couture. You may compete with JLM Couture following your employment with JLM Couture. Now, the FTC's new rule does not affect any terms or condition of your employment. Under you may also seek you may seek, and it does not affect other terms and conditions of one's employment. Now, definition of non-compete clause means, as provided under part 910.1, is a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person, where such work will begin after the conclusion of the employment that includes the term of the condition, or operating a business in the United States after the conclusion of the employment that includes the term or condition. Now, for the purposes of Part 910, term or condition of employment includes but is not limited to a contractual term or workplace policy, whether written or oral, you know. So, through though it will not be effective 120 days after it was published, non-competes are not void right now and doesn't apply to breach of contract dispute, which is the circumstance in this case between Hayley Page Gutnam against JLM Couture, and doesn't ban confidentiality or non-solicitation provision. Inanu. Good. So, in wrapping up, it is important that employees or influencers or those who work in whatever industry it may be understand their rights and responsibility need to be able to get a lawyer on their side to help them define in a clear language and give them a better understanding of the contract they will be signing regarding IP ownership, social media accounts, which is more or less becoming like intangible assets. I mean, you're seeing people come up with EPKs or their portfolio, and they're like, "Oh, I have 5 million followers, and I have about 1 billion views on all platforms, etc., etc." But this case basically highlights the complexity and legal challenges that can arise when personal brands and corporate interests intersect. In the context of the fashion industry, these rights can be deployed at various phases of a product life circle. Employees in the fashion industry should have a clear understanding of IP rights, non-compete clauses, as they can significantly impact their career and future opportunities. It is always advisable to consult with a legal professional when entering into contracts that involve these elements, and when dealing with stuff like this, because at the end of the day, the company will always look out for their interests. What alternatives can employers exploit to protect their interests? There is provision for what is called clawbacks, which is similar to forfeiture for competition, where an employee will be required to repay compensation already paid if the work is for a competitor. Forfeiture for competition basically is an agreement that provides that an employee would forfeit a benefit if they compete with the employer. May have garden leave clause, which is popular in the US, which provides for payment to the employee for a defined period of time without requiring the employee to perform any form of duty. Non-solicitation agreements prevents employees from soliciting clients or customers or other employees of the company where they work for a certain period of time after leaving the company. Confidentiality agreement for non-disclosure of commercial information that has value. This alternative kind of creates a balance between protecting the employer's interests and allowing employees the freedom to pursue their career goals. It is also always advisable, I'm stressing it, to consult a legal professional or a law firm when considering all of these options. So you're not going to be the next Hayley Paige that I may be talking about someday, but it won't be bad if I talk about you for educational purpose, of course. And take note that this episode or any of my podcast episodes is not legal advice. It's just for educational purpose. So if you find them useful, thank you for listening. And see you. Thank you for listening to IP Series Podcast. If you enjoyed this episode, please subscribe, rate, and review us on your favorite podcast platform. Don't forget to share it with your friends, family, and colleagues. You can also follow us on Instagram at IPSERIES with Esmeraldo ESQ, or Twitter at IPSeries1, or send us an email to ipseriesinfo@gmail.com. Until next time, stay tuned and stay informed.